Good morning, Ms. Kukowka.
Good morning, Your Honors. Varsha Kukowka for the Commonwealth. A Franks versus Delaware challenge has two components, intentionality and materiality, and neither was satisfied here. As to intentionality, there was no deception, there was no animus, there was no intent to mislead the court. As to reckless misrepresentation, this court has applied a standard whether the police affiant would have any reasonable ground to believe the statement that was...
Ms. Kukowka, I'm sorry to interrupt you. I just have a fact question. What does Mr. Brown have to do with this appeal?
The co-defendant, Your
Yes.
Honor? Well, information that came out through the wiretap is affecting that.
Is affecting him, but the wiretap involved Long, am I right? I mean,
The wiretap was of Derek Long's
Right.
conversations.
Right.
Before.
And so it's just because
Paul
Brown
Brown
is affected also because he's a co-defendant, is that it?
That's right. The Brown
I take it some
filed
of the wiretap conversations implicate him.
led
Right,
to,
right, okay,
to the
that's all,
suppression
but
motion.
that's, but, okay, fine, thank you.
On the reckless standard for a false statement as whether the police affiant had no reasonable ground to believe the statement was true. So here...
I'm sorry, but let me ask you this. In your brief, you say that Trooper Moran left parts of conversations out of the affidavit because he found them insignificant on the issue of probable cause, page 15.
Yes.
Does that mean that he was picking and choosing what information to provide in the affidavit based on what he thought was important?
He, his colleagues, and his superiors were discerning and selective in choosing the items that gave them serious concern. And that is what was selected. And the warrant judge...
With all due respect, is that how we do it? We leave it to the police to decide what they think is important?
There certainly is some deference to the expertise and the experience of police in looking over a warrant and an affidavit.
But wouldn't the limit of that obviously be that if they, in choosing what they consider to be important, if they left out contradictory pieces of conversation that would change very much the meaning of this? I mean, in other words, there are constraints under which they operate. Wouldn't that be what you'd say?
I would agree that if there were contradictory pieces of information, a case that the defendants cite as to omissions is a case that the appeals court issued last October, Commonwealth versus Ramos. That's a good example where the information was contradictory that was left out. The affidavit said that the canine had alerted to 150 hits that led to convictions, when it was really much, much less. Most of those were in practice sessions, and it's a very infinitesimal percentage. That was a cold, hard fact that was left out, as well as false alerts that dog had made, as well as the trainer having informed one of the police officers that the alert in that particular case could have been a false alert. So that is cold, hard information that contradicts the information that was in the affidavit. Here, there is nothing like that. If I go...
Well, the judge lists a number of omissions in her findings. For example, she talks about the conversation. Moran listened to a 30-minute conversation between Derek Long and Richard Long and heard nothing to support his conclusions. And she says, not only did Moran not include the details of this conversation in his affidavit, but he failed even to mention that he had listened to a conversation between the two Longs. She talks about Moran listening to a conversation between Derek Long and Gillian Gibbs. Another conversation he failed to report in the affidavit. And she said, regarding that conversation, this conversation is hardly consistent with an effort to recruit Newsom into a plot with others to kill a witness, nor does it suggest that Long is so concerned about that witness's testimony that he would kill her, as Moran implies in his affidavit. And the judge goes on to talk about the conversation between Long and Courtney Ford. There are several omissions that the judge points to. Are you saying that the judge was wrong? And
Yes, the judge was wrong. First of all, the trooper listed that he listened to the conversation between Derek Long and Richard Long. So that's a mistaken fact in the judge's ruling. Second of all, the judge took conversations that were fluff. They were conversations that had nothing to do with these veiled points that the defendant was trying to get across. And throughout the tapes, he's saying, I can't talk on this line. The line is recorded. He has got to make, or he chose to make, very specific, wary statements that brought up concern among the police, knowing there were at least two people involved in this or more, and that there was an eyewitness, and that there were still guns on the street, that this defendant and one of the suspects had prior convictions for intimidation of a witness and gun possession, and that this was what was important. When the judge went back and did her own kind of benign gloss on what these specific points that had so concerned law enforcement, she did a kind of a different analysis. It was like telling a different story.
Isn't that the point?
Pardon me?
You said she did a benign gloss.
Yes.
Well, one way to view it is she did a benign gloss and they did a non-benign gloss.
Yes,
You
with their expertise and experience.
Yeah, but you draw a negative inference when somebody's saying this conversation is being recorded. I can't tell you the number of times when I'm on a cell phone, I remind somebody at the other end, if I'm talking to a court personnel, I'm on a cell phone. Be careful. You don't know who's listening. Are the people to conclude that I'm engaged in illegal activities?
The point is that there was enough said to raise serious concerns, and the trooper explained his concerns at the hearing by saying that, did the fact that this defendant had previously been convicted of intimidation of a witness concern you? And he said yes. He's not talking about beating it at trial, that term saving the indictment. He's talking about not having the indictment go down, and with an eyewitness in front of the grand jury, the only way you can get rid of an indictment is to get rid of the eyewitness. And this is
Could
what...
I ask you a question, Ms. I am puzzled by the provision of the statute that says Chapter 272, Section 99F3 provides that if the applicant's information and belief is derived from tangible evidence or recorded oral evidence, a copy or detailed description thereof should be annexed to or included in the application. If a copy of the phone conversations recorded had been attached, wouldn't that have obviated all this? Because then the judge, if she wanted, could have looked through, could have listened to everything.
That
And
is
we
the
wouldn't have
point,
this
Your Honor.
discussion. But was a copy attached to it?
It was not, but that
Okay,
is...
why wasn't it?
Well, that was asked point blank by the motion judge to the trooper, and he explained...
By Judge Sanders, you mean? The motion
Yes,
judge, yeah,
and
okay.
that was, and he explained, and that's on page 42 of my brief, his answer, is that I would have had no problem doing that.
And I asked her if she wanted to have any more information. She said no, but that isn't the question. If the statute says it, you don't ask somebody if they want it. The statute says you do it.
It does, or give a detailed explanation. And in paragraph...
Well, it's pretty hard to give a detailed description of such a long conversation. So, I mean, wouldn't this whole thing have been... Why? I just don't understand why you didn't attach the recordings. Then you wouldn't have a problem.
Well,
Then nobody could say you left anything out, because there it is.
Well, our position is that there was no deception, that the presentation to Judge Fabricant was that there were conversations, and these were things that were...
Okay, but how do you excuse a violation of the statute? It seems to me the parties don't make as much of a deal of this as they should, either party. But, I mean, am I wrong in my reading of the statute?
The statute says that, but it doesn't say that that alone would be, cause to suppress the evidence. And certainly there was a description in paragraphs 17 and 18 of the trooper's affidavit that gave an explanation of his going to the jail, listening to the conversations, that there was a three-way conversation. It certainly wasn't just conclusory information, and he certainly didn't just say, here's what the defendant said. He gave the full context of where he heard the conversations and what they came from, and that was what was important.
I suppose your best answer is that if the judge who allowed the wiretap application had wanted to hear the whole thing, she could have asked for it. I suppose that's the best answer, and the trooper did offer any further information to her, but okay.
Now, at the very least, why does that provision not take this out of Frank's? Why can't the motion to suppress judge consider the evidence that B3 provides should have been provided to the issuing judge and consider it and simply view it in a probable cause context? Why must there be a finding of reckless disregard or intentional falsehood? Why can't we simply look at it to see whether or not Judge Sanders, considering all the information that should have been before Judge Fabricant, found that there was not probable cause?
I agree, Your Honor, and that the Commonwealth says that there should not have even been a Frank's hearing.
But it's the same. I mean, all she did at the so-called Frank's hearing is consider the evidence that should have been provided to Judge Fabricant.
Exactly, and went beyond the four corners as well, which...
Well, but the four corners here should have included what she read. I mean, that's the point. The point is that B3 is a little bit unusual. It says the four corners of the affidavit should have contained the very same tape recordings that Judge Sanders read. So I don't see why it's a problem for Judge Sanders to look at it. I don't think she needs to make a Frank's finding to look at it. She simply, under B3, would be entitled to, and therefore it seems that our decision is not whether or not there was intentional or reckless disregard. Our question is simply whether or not Judge Sanders erred in finding that there was no probable cause. Isn't that how
By
we should do it?
putting the omitted back into the affidavit, yes, and by reassessing an interpretation, not factual information. And that's the difference between this and the Ramos case or any other case where there are factual omissions about, say, the defendant's criminal history or that the drugs had already been tested negative. I'd like to use a little bit of time on the point of organized crime. In the last 28 years, there have only been, that I could find, 7 non-drug cases where there was a challenge on the basis of wiretap. Well, most of them did not have a warrant, but under the wiretap statute for the point of organized crime, and this case fits solidly within them. Specifically, the kind of evidence in Thorpe or in Lycus, there was, the statement that we have kidnapped someone. Simply the plural was enough to give rise to the fact that there was an ongoing conspiracy and that more than 2 people were involved. In the I think the case that's most similar to this one is the Terzian case, and all of these cases are cited in my brief. And there was only one of the 7 where the court, there 4 are this court and 3 are the appeals court. The Jarabek case, where the court knew that there were 2 identified individuals trying to extort from a person who had a contract with the school. It was all like a known quantity. In Terzian, the factors that apply here. The police lacked a clear picture of all the people involved and the extent of the crime. It was not a single, isolated, solitary criminal act. It was, the police here didn't know how far the defendant and his compatriots would go to achieve their desired goal of saving that indictment. There was a certain level of organization and planning, continuing conspiracy designed to either intimidate a witness or fabricate or suborn perjury. The nature of the crime itself lends itself to this inference of organization and discipline, and certainly what you didn't have in most of these other cases was a previous conviction for intimidation of a witness and for gun possession that you have in this case.
But is there any case in which the motivation for the crime was not money or drugs?
Yes, Terzian, the nature of the point, the motivation was because this defendant lawyer had a client who had a wife or girlfriend whose son did not want a felony conviction because he wanted to go into the military. That there were no guns, there was no money or drugs involved in that, and it's very similar to here, and I'd say here is much, much more serious than someone not being able to get into the military, trying to thwart the grand jury's work.
Well, I mean, murder is always serious, but it doesn't mean that it's organized crime.
Murder and potential for intimidation of a witness.
Thank you, Ms. Kukowka.
Thank you, Your Honors.
Good morning, Mr. Grossberg.
Good morning, Your Honors. Bernard Grossberg for the defendant appellee Long. I would preface my remarks by stating, as I've argued in the brief, that what the Commonwealth sought to do here was to use electronic surveillance in what is a garden variety murder. And
well, it's garden variety. That's a terrible word to say, because you've got at least two people involved in essentially the execution of another person. You have indications that there are people on the outside that are prepared to take steps to thwart the indictment, that there are other people involved in whatever that might be. I mean, that seems to me to be something more than just a garden variety shooting on the street.
the difference I have with that and the allegation that the Commonwealth is relying upon to take it out of the so-called category of garden variety murder is that if there is an organized group, organized crime, that seeks to thwart the indictment or to take care of the best case scenario for the Commonwealth, take care of the eyewitness, that's prospective. That might be organized crime that the electronic surveillance seeks to discover prospectively. And the statute is designed to talk about organized crime as to the recipient crime. Here, and Moran himself says, we are seeking evidence of an organization that may exist in Norfolk County, an organized group of people to stop, if you, in the best case towards the Commonwealth, stop the indictment. That's prospective use of the requirement of organized crime. There's no organized crime as to this particular murder. There's a
What
fight
about a
between...
conspiracy to do that?
Excuse me?
An existing conspiracy to do just that?
If there was a conspiracy.
Well, I mean, that's...
But that's what the perversion of the telephone calls is what the Commonwealth is relying upon.
Well, I don't think it's a perversion. I just think it's two different people or two different ways of looking at the same thing. You can look, I mean, and that happens all the time in all sorts of conversations in everyday life. You read one thing into something, I read another thing into it, and it's this.
Correct, but...
Neither is a perversion.
Well, it's, I would say, a distortion to try to, in this case, a distortion to try to establish probable cause to allow the Commonwealth to discover who they already know is the second shooter. They know that the second shooter, by listening to the telephone calls from the jail, is someone named C. C is Casino. Casino is Courtney Ford. They know that Courtney Ford is an associate of Long. They know that Courtney Ford has a record. They know that the telephone calls to some of the women who are in...
And how much do you think Courtney Ford is going to tell them?
No, but the point
But,
is...
and when did they find out, by the way, because it just wasn't clear at all, and you may not even know, but when did they find out that Ford's father was a probation officer, a police officer?
A police
whatever
officer.
it was, police
That was not clarified. I
we don't
asked
know that.
Moran, did you know that Courtney Ford's father was a police officer? He says, I don't know if we found that out before the wiretap was
So we just
issued or
don't know
not.
that.
Mr. Grossberg, who is Mr. Brown?
Yeah,
The
that's
co-defendant
what I
in this
kept
case?
asking.
Courtney Ford was subsequently charged. Courtney Ford cooperated. Courtney Ford alleged that the second shooter was Mr. Brown.
So the police, you're suggesting the police suspected Courtney Ford was the second shooter?
I say it's more than suspected. I say that by the shooting occurs on the 9th. With less than 24 hours later, Mr. Long is arrested. On the 12th, or the 13th at the latest, the police have definite information that Courtney Ford is involved.
Was with Mr. Long?
Was with Mr. Long. I would suggest that there was enough evidence to arrest Mr. Ford at that time. And what's crucial, as the motion judge found, the police did hardly anything to follow through on the involvement of Courtney Ford.
What was the evidence that you said established probable cause to arrest Ford?
Excuse me, Your Honor?
What was the evidence that you say established probable cause to arrest Ford at the time the police were seeking the wiretap?
Ford makes the telephone calls to the other witnesses before and after the shooting.
And the towers, they had him right at the scene.
The towers put Mr. Ford within less than a half a mile of the shooting. Mr. Ford is either a relative or a close associate of Mr. Long. I believe that at some point a witness comes forward that has seen Mr. Ford remove some items from the apartment where the earlier fight occurred. Maybe they didn't have enough probable cause at that time.
You would be arguing against that if an arrest warrant issued on that, and you might well succeed.
Well, they certainly had enough to charge him with an offense, but they also did not take any steps to surveil Mr. Ford, to actual police investigation.
That's a better argument, I think.
They couldn't find him.
Here's what the judge said. The judge said Moran admitted at the hearing that not only did police suspect that Ford was the second shooter, but they also believed they had enough to arrest him. Police had Ford's telephone number, had an address for him, and knew that Ford's father was on the MBTA police force. Other than talking once with his mother, however, police made no further effort to track down Ford before applying for the wiretap warrant. And then the judge goes on to say that Moran testified police did not pick up Ford for questioning because they did not want to tip him off that he was a suspect. This explanation undercuts Moran's claim, however, that when he wrote the affidavit, he was very concerned that Ford and others linked along would try to kill the witness. That's what the judge found.
Well, not only would I agree with those findings, but at the Franks hearing, the evidence of whether or not there was any type of threat to this witness was purely speculative. The name of the witness was announced in the newspaper. Moran tried to excuse it by saying, well, we didn't give it out. The fact is that she was known. There was no efforts behind the scenes to locate her. She wasn't offered any type of protection, so I would say that that's a red herring in terms of the police having a concern.
I thought the Commonwealth brief said that the officer testified that he believed there was something offered to her, but he didn't know what it was.
He thought that she may have.
But then you can't say that no offer of protection.
Well, there was
made.
nothing other than his thought that perhaps she was offered some type
If
of.
that's the only evidence, that's not evidence that no protection.
Well, but they didn't bring anyone in on it. It was open. It was in Frank's hearing. They could have produced who they wanted. She didn't. There was nothing other than him saying, "I think that she was offered protection." But the point that I'm trying to make is no organized crime. It was prospective, if anything, and there certainly was no effort to satisfy the requirement of necessity of exhausting normal investigative techniques. Crucially, Long makes a telephone call to his girlfriend. That's the call that Moran listens to. The girlfriend connects Courtney Ford on the three-way. No effort of any nature is made to go back to the girlfriend to either ask her if she will cooperate voluntarily, to offer her immunity, or more importantly, any effort whatsoever to trace the phone call that she makes to Courtney Ford to locate Courtney Ford. Now, that's certainly not an exotic police technique. That's basic police.
I'm sorry. First of all, the officer is listening to this conversation after the fact. This is a recording done at the prison of a phone conversation.
Right.
So the officer's not listening in saying, track that phone call. He's listening to a recording after the fact.
Prior to the issuance of the warrant.
Right.
So prior to the issuance of the warrant, they know that Long's girlfriend is in touch with Courtney Ford,
Right.
who they suspect as being the second shooter. And
No, but you said the police, they didn't even trace the call. I'm trying to
Hey,
figure
if
out
they
what you're
trace the
talking
call
about
and Courtney Ford was at
I didn't mean
McDonald's getting
trace
a
the
hamburger
call, I'm
that
sorry.
day, what is it
They
going to
could
do?
have gotten the telephone records or made an effort to find out to whom or what number the girlfriend used to reach Courtney
But
Ford.
they're not arguing that they couldn't have gotten Courtney Ford. That the argument is that they didn't want to tip him off, right? I mean,
Well-
I'm not saying you have to accept that, but I mean, whether they could or couldn't have. I mean, they're not disagreeing they could have located him.
But the question is, tip him off to what? He's already supposedly in hiding. He knows that based upon his conversation alone with Long,
Tip them off that they suspect someone's going to intimidate or kill a witness.
excuse me, Your Honor?
Tip the co-conspirators off that the police are aware that there's going to be witness intimidation or killing. That's the tip-off that they don't want to give.
Well,
That's what I assumed it was.
I would disagree with that because the name of the witness was published. Courtney Ford is supposedly
No,
in
you
The
mean then
fact
because
that
the
the-
name of a witness is published, we're
No,
going
but
to
there's
assume
no
the witness
efforts.
is going to be killed? Is
There's
that
no,
what we've
there's
come
no
to?
efforts made in any way to knock off the witness, and she's.
You mean to protect the witness?
There's no efforts made to offer her protection. There may have been efforts to offer her protection, but she has not offered protection. But even were that the case, how does the Commonwealth get around the other requirements of the statute of organized crime? Moran's affidavit doesn't mention organized crime, and I would argue, as the judge found, that what is required is an exhaustion of normal police investigative techniques, and it wasn't even tried. We didn't have to, as Justice Gantz indicated, the judge did not have to get to the Franks hearing. She could have decided this case on the basis of the Moran affidavit that it didn't comply with the statute, but she did reluctantly, as she indicates in her order, get to the Franks hearing to get to the issue of intentionality and reckless conduct. The case could have been decided on the Moran affidavit, and it's interesting that the Commonwealth appears before this court today starting with the issue of whether or not there should have been a Franks hearing. It doesn't deal with the crucial issue of whether or not on the Moran affidavit alone there was grounds to satisfy the statute. So I would ask the court to uphold the motion judge's findings.
Thank you, Mr. Grossberg.
Good morning, Justices. Kevin Mitchell on behalf of Mr. Brown.
Good morning, Mr. Mitchell.
Your Honors, I would suggest that in reference perhaps to a comment that Justice Cordy made about that there were some indications that people are on the outside to help, or even comments by Justice Cowan that there may have been an alternative interpretation. Each side sees the tapes differently. The reality is, in this case, the motions judge listened to those tapes. And what I suggest she has said to you, and you will also come to that conclusion when you listen to those tapes, is that there is no basis to find that there was, in fact, indications that there were people on the outside to help, or in an alternative interpretation of what was said.
So
When
you
you
just say
look at-
there's no probable cause.
There is absolutely no probable cause for the designated offense, and certainly not for the designated offense connected to organized crime. Putting aside the argument...
designated offense being what? Murder?
An intimidation of a witness at any level, be it verbal or be it murder. It just doesn't exist. And you get that by doing exactly what the judge did, by listening, not just to reading the words,
Now,
which
we're
is
going to listen
content.
to these tapes, and we're going to understand that these people know they're being tape recorded. So
Absolutely.
what we're looking for is what an experienced police officer would look for, is clues as to what is likely unfolding here in a very controlled environment.
And I invite the court to do that because that's exactly what the motion judge did. And what the court will find, for example, is
Okay, what does he mean, though, by stopping the indictment? I forget the exact word. How
Save
save
the
the
indictment.
indictment. How are we going to save the indictment?
here's
What
what
did
you
he
need
mean?
to do, Your Honor, Justice. You need to go back and listen to that 8-minute conversation, which was denied to Judge Fabricant. What that
I don't think it was denied.
Well, it
wasn't
was not Judge.
appended. It wasn't
was not.
appended.
Well, it was a specific act because at least 3 different times Trooper Moran said, when asked why didn't you do it, he said because I was looking for probable cause and I was looking for what I saw as probable cause.
Well, in any
for what
event,
I did.
What does it save the indictment mean?
Here's
what
what
is he
I
gonna
think
do
it
to
could
save
easily mean within the context of what that conversation was. In the first conversation with Tanea Newsom, which is Exhibit 2, Track 1, he talks about how he had an alibi. He was in Boston when this occurred.
So
That's
doesn't he talk to his lawyer about that?
he can, but he can also talk to his friends. He's meeting his lawyer for the first time. That's in paragraph 7. When, in fact, he is talking to Tanea Newsom, which is track 4 of Exhibit 2, offered, he makes the statement, I need to save that indictment. Her response to that, immediate, not later, is that the crime is BS. And then they go into the bulk of that conversation talking about how he was in Boston, wasn't there. That he was in, he has his people in Boston. This could very easily, just on the crime itself, be this individual doing no more than trying to locate who his alibi witnesses are. At this point in the case, the only evidence of all the prior 16 paragraphs that suggest that Mr. Long is involved in this crime is the single witness who comes forward and says, I saw him running off. There is certainly evidence he was in a motive, earlier fight. He volunteers that to the police. It could very easily be he needs to marshal who his witnesses may be so he can save that indictment. What you don't see, and even more
Wait a
significantly...
minute, how is he going to save the indictment?
Because
Is he going to present evidence to the grand jury?
Well, he is not an attorney. He needs to get his evidence to his counsel to do what he expects his counsel to do. It won't be the first time in the history of the law that cases have not proceeded to indictment once evidence is developed. All I'm suggesting is, even if you go to the next...
You're attributing a lot of sophistication to this guy.
Mr. Mitchell, let me tell you what the judge said. She said, the actual conversations reveal a far different concern. And regarding the reference to saving the indictment, she said, moreover, the term save the indictment upon which Moran hangs his hat is itself ambiguous and could mean only that Long needed to talk to his friends in order to prepare a defense.
Exactly, which is what I think the court saw in that. But what the court, and this court, will clearly see in all of the dialogues is that there is absolutely no existing organization of people. Tanea Newsom, who he's talking to, in the way in which he responded, is not a member of an organization, and the court saw that. Richard Long, who is cited, is never even discussed within a 30-minute conversation that Trooper Moran listened to but did not cite, which follows, never once mentioned other than please get me money. Courtney Ford specifically says, not mentioned in paragraph 19, Courtney Ford specifically says, Richard called me to talk about it. I wouldn't talk to him. Way to be. Fall back, man. Fall back. That's the actual line. Here you have an alleged conspirator indicating I won't talk to another alleged conspirator. None of that, which was in existence and known to Trooper Moran, was offered in a very simple 3-minute tape, 8-minute tape, which could have been in compliance with F subsection 3, could have easily been put before us, and the judge would have had a fair opportunity to make the inferences.
Thank you, Mr. Mitchell.
Thank you.